Thank you, Vijay.
Yeah, I'm recording the session. My name is Vilas. I'm a certified financial from New Jersey. And today we have a Mark. And just introduce yourself and let's start. Priya, please go ahead.
Hi, um, hi, Vilas. Few of my friends are joining this meeting. For now, I think Pratik is one of my friend. He's interested in this webinar. I have a couple of my friends, three other friends who are going to join the meeting soon.
Okay. Yeah, thank you, Priya, and your team. Welcome. Yeah,
Yeah.
just your name and your state, who invited. Just let's go quickly. Another 2 minutes, the session will start.
Hey, hi everyone. This is Anand. I'm from New Jersey, so I got this invitation from Vilas. Thank you, Vilas.
Yeah, thank you,
Thank you.
Anand.
Hi, this is Arunima, and I got the invitation from you, Vilas.
Oh, thank you, Dr. Arun Garu. Thanks
I'm
for
from New
joining.
Jersey. Yeah.
Yeah, thank you.
Hey all, this is Pratik. I got the invite from Priya. I'm from Minnesota.
Oh, thank you, Pratik. Everyone, please unmute yourself and introduce. If possible, you can come on the video. That would be great. If whatever chances. I know you are not driving today because due to snow. I hope everyone's safe.
Hi, this is Kishore. I got the invitation from Shashgiri. I'm from New Jersey, Edison.
Oh, thank you, Kishore Garu. Yeah, already Shashigiri also in the line and he's with another 4 friends. Yeah. And then, yeah, we have another 2 minutes. Let's introduce yourself, your name, your location, and who invited.
Everyone, this is Sandesh from Dallas, and I got your invitation in a WhatsApp group from you, Vilas.
Oh, thank you, Sandesh.
Thank you.
Yeah.
Hi, this is Ajay. I just got the invite from Konda Reddy.
Oh, thank you, Ajay. Welcome. From New Jersey, right, Ajay?
Yes, we met over the last time, Vilas.
Oh, right.
Hopefully
Yeah.
remember. Yeah.
Got it. Yeah. Thank
Sure.
you, Ajay. Oh, nice. You're not in the video, so that's why I couldn't find. Sorry.
Yeah. I just
We'll
joined.
try to join in the video if you're possible.
Yeah.
Yeah.
Sure.
Kamalakar.
Yeah, Vilas, thank you. Yeah, I'm Kamlakar Reddy, and I got invite from the Reddy the group in USA, and I'm from Indiana, Vilas. Thank you.
Oh, thank you, Kamalakar ji. And Koti. Suresh Garu.
Hey Vilas, I got the invite from you.
Okay, yeah, got it. No, just I'm introducing for the sake of other people also. Just
Okay.
want to. Today is a snow day, so just introduce. Just want to warm the meeting session also. Yeah, Manya and Yogita, Ratsi, Dev. Yeah, please introduce yourself. Your name, your location, who invited. That's it.
Hey, hi. My husband Jagdish invited me to this meeting. Yeah,
Oh, nice. Yeah, welcome.
Atlanta, Georgia.
Atlanta. Okay.
Yeah, Vilas, I have two friends on this call, Koti and Jitendra.
Okay,
Koti is
yeah.
from Pittsburgh and Jitendra is from Dallas.
Okay. Koti, Jitendra, welcome.
This is Rashik Reddy. I was invited by Lakshma Reddy.
Oh, okay.
I live
Thank
in
you,
South
Raj.
Carolina.
Okay, Raj, got it.
Thanks, Raj.
Hi, this is Dev. I'm joining from California. I'm invited by Lakshma Reddy.
Okay, Dev, thank you.
Namaste Vikas ji, Ankush here.
Oh, Ankush ji, namaste. Yeah, welcome.
Namaste Vilas ji.
I hope everyone joined. Yeah, we'll start in 1 minute. Konda, are you ready? Is there anyone else to introduce your name, your location, and who invited? Yeah, people are joining now.
I was invited by Geeti Garu. I'm from Albany, New York.
Oh, thank you, Manji.
Yeah, Vilas, please go ahead. Why? Because right, almost like 7 minutes. It's okay. Yeah. Yeah, Konda,
Yeah,
please go ahead.
actually, we got sign up around 80 people, so that's what we are waiting for
It's
2
okay.
minutes.
Yeah.
Got it. Konda, are you ready?
Yeah, okay. Thanks,
Yeah.
Vilas. Hi, good evening to everyone. We appreciate everybody to join this valuable class session and for your valuable time. So I would like to introduce myself. I am Konda Reddy. I'm a partner with Vilas. I'm joining from Marlboro, New Jersey, and I would like to invite one of the most knowledgeable vice president at Netla company, a director of customer service at Netla, Mr. Mark Steinman. He's having a vast experience for about 10 years at Netla. So before proceeding and starting with the session, so I would like to request everyone to have their cell phones muted, and if possible, please be on video. And also, like, if you could, if you have any questions, please note it down and let's ask them all together at the end. And if possible, like even if you are in the middle of the session, so try to put your questions in the chat and we will be able to, like, gather everything, and we'll ask at the end of the session and get answers from Mark. And without any further delay, let's hand it over to Mark. So that's pretty much Mark, all is yours. Please go ahead.
Yeah, thank you. Yeah, I appreciate it. Thank you so much. And Bill, thanks for having me here today. Today we're going to talk about the very exciting world of estate planning. So today we're going to talk about what is estate planning. We're going to talk about all the documents and why you need each and every one of these documents to have a full comprehensive estate plan. And then at the end, probably the most important thing we're going to talk about. We'll talk about ramifications. What are the ramifications if I don't have this and I pass away? What's the ramifications to my spouse, my kids, for not having these documents? So we'll talk about all of that in about a 15 to 20-minute presentation. And then we'll answer any questions that you have at the end. So go ahead and feel free to put those in the chat bar so you don't forget them as we're going through the presentation. And we'll answer those at the end. But let me go ahead and share my screen. And I will share the presentation here. That way you don't have to look at me. Let's look at what's important. And that's the slides, right? And I always share this slide as my first slide, because I think this slide pretty much gives you every reason of why we need to do our estate plan. And that's family, right? We do our estate planning really not for ourselves, but we want to protect our family. We want to make sure that everything that we have now or whatever we acquire in the future, we want to make sure that those assets get distributed to our beneficiaries, who is usually our spouse, our kids, maybe our grandkids. We want to make sure that they receive those in the most time efficient way and the most cost effective way. And that's what we do every day at NetLaw. We help families use our software to help them create their estate planning documents online in the convenience of their home or at work or wherever they have about a half hour to an hour to complete all of these documents. So the first question that you probably have is, well, what is NetLaw? NetLaw is an IT company. We're a document creation company that was created out of an estate planning law office called the Hargrove Firm in Louisville, Kentucky. That's where I'm from. That's where our corporate office is. And the reason that our law firm created this sub-company NetLaw was because back in 2012, we read in a Bloomberg report that said that 60% of Americans did not have their will. And that was concerning to us, right? Because 6 out of 10 people aren't coming in to get their estate planning documents created. And it was really concerning because if you ask anyone, hey, do you have your will? Most people would say no. And you know what they always followed up with? I know I need to do that, right? It's one of these things that we know we need to do, but one of the biggest things that we procrastinate on. And there's several reasons why. One is cost. And they're right. It is expensive to come into one of our law offices or any of our law offices and get your estate planning documents done. It is expensive. But you know, the second reason that we found was even more worrisome than just the cost. From what people told us, there is a large misconception out there. People had the misconception that if they weren't multimillionaires, if they didn't own multiple properties, if they weren't a business owner, then estate planning wasn't for them. That's for the wealthy people. But nothing could be farther from the truth. If you have a house or a car or a bank account, you have an estate. If you don't take care of it, the state will come in and take care of it for you when you pass away. And nobody wants that, right? We want to make sure that we stay in full control of everything. So that's what we did. From our law office, we created NetLaw, an easy way for you to use our software to complete your documents. How did we do it? We went out and we hired attorneys in all 50 states to come in and build our software. We wanted to make sure that no matter where you live at now or wherever you move to in the future, you have the ability to use this software to make sure that your documents are state specific. Because every state has rules and regulations that have to be followed according to the American Bar Association. So we wanted to make sure that we had our documents fully approved by the American Bar Association. And we did by having those attorneys come in and build our software. So when you use this software, the documents that you were receiving are the same documents you would get from an attorney in every state from our law office. And one of the biggest things that separates NetLaw from everyone else is we are the only ones to win the James Keene Award from the American Bar Association. This is an award handed out each year to the company that has the best online delivery of legal documents. That's from the American Bar Association. Again, we are the only ones to win this award. This was awarded to the Hargrove firm for their creation of NetLaw, the best online delivery of legal documents. And these are all the documents that you get in our full premium probate avoidance package. And as you can see in the middle of the screen, free spouses plan. So one plan covers both spouses. Both spouses get to create their full set of documents by purchasing the plan just one time. So let's run through these documents and talk about why they're so important. And I always start with the will. To me, the will is the most important document because with your will, we're going to really concentrate on three things. Number one is your executors. Your executors are probably the most important people that you're going to name because they're going to handle everything when you pass away. Your executor is responsible for making sure that all of your assets get distributed to your beneficiaries. They're responsible for filing your taxes at the end of the year. They're responsible for working with your creditors to make sure that they're paid off. They're responsible for taking your will and filing it with the county records department. So they have a lot of work to do. Not only do you get to name your main executor, but you get to list your successors or your backups or your helpers, right? Someone who can help the main executor handle all of this. One of the greatest things about this is, and it's one of the biggest questions that I get about executors, especially from your community. Can my executor be someone from overseas? Absolutely. Absolutely. As long as they're over the age of 18, someone from overseas can be your executor. But you have to have a successor from your state. Because again, there's a lot of legwork that has to happen. They're going to have to go to your house and find documentation. They're going to have to go to your financial institutions, maybe your place of work, and get all kinds of documentation. Something that someone from overseas can't do, right? So it's very important if you're going to name someone from overseas to handle everything, at least one of your successors has to be from your state. So that's number one, executors. Number two, guardians. If you have children under the age of 18, and God forbid something happens to mom and dad, who's going to have custody of your kids? Who's going to raise your kids? In our will, we're going to list our main guardians. Who's going to take care of our kids? But just like with your executors, we have our successors, someone that can be that backup. Because if someone is your guardian from overseas, it's going to take a while to get over here. You need to make sure that someone's listed from your state that can grab the kids. And the last reason we do our will, We call it specific bequest. What that is listing all of our assets and naming those beneficiaries. Here's what I have, and here's who's getting it. So there's no confusion, there's no family fighting. Everything's listed out nice, neat, and orderly, right? So everyone's on the same page. Those are the 3 reasons why we do our wills. Again, executors, guardians, and specific bequest. Children's trust is the second line item. This is for those parents that have underage children. Again, mom and dad pass away. When do you want your child to receive their inheritance? If you do nothing, they will receive everything when they turn 18. Sounds good, right? Mom and dad have passed away. Let's get the kids everything they need as soon as they become adults. But let's remember they're 18, not the maturest of individuals, right? And with the amount of money that we could be leaving them, maybe not the best choice. But the children's trust allows you to dictate, maybe they don't receive their inheritance at age 18. Maybe they receive it at 21 or 25. Or maybe you break it up into installments, some at 21, some at 25, some at 30. So as they go through life, some money is coming in. Parents love that option. Third line item is our durable financial power of attorney, naming someone who can make your financial decisions for you if you're incapacitated, you're sick, you're in the hospital. Maybe it's simply that you're overseas on vacation for 3 or 4 weeks and something happens over here. Hey, you don't have to rush back. Let your power of attorney handle everything with your discretion. We even have 3 healthcare documents. Remember in the beginning I said this was a full comprehensive plan. Not only are we taking care of your finances, but we're taking care of your healthcare documents as well. Healthcare surrogate is your medical POA. Who's talking to the doctors and nurses on your behalf? And the HIPAA authorization grants access to all of your medical charts to your healthcare surrogate or anyone else of your choosing, so that they have all of the information they need to have an informed decision with the doctors. And the last healthcare document is your advance directive, your end-of-life decisions. What do you want to happen at end of life? Do you want to be hooked up to a machine and kept alive? Or do you want to pass naturally? Do you want an autopsy or no? Do you want to give any body parts to science or no? You stay in full control of everything. We even have a pet trust. So if you're a pet lover, you have pets, something happens to you, someone's got to take care of those animals. You can leave money behind to that person so they can use that money to take care of your animals. And then the last document, the revocable living trust. This is the document I get 90% of my questions on every day. Our trust is a probate avoidance trust. What that means is you can transfer some of your major assets that do not have named beneficiaries, like your house, your cars, rental properties, your businesses. All of those assets do not have named beneficiaries. You can actually transfer those assets out of your name and transfer them into the ownership of the trust. And the reason that you want to do that is because when you pass away, if there's no trust, all of your major assets that do not have named beneficiaries will be frozen by your state for a period of 6 months to a year. The reason that your state comes in and freezes those assets is because they want to make sure that all of your creditors are paid off first before any asset gets distributed to your beneficiaries. That's just how it is. But if you create this trust and you transfer those assets out of your name and into the ownership of your trust, when you pass away, those assets distribute to your beneficiaries right away. And just because the trust owns those assets, you're still in control of everything. You're the trustee of your account for as long as you're alive. So you don't lose any authority or power. You can buy and sell accordingly. You lose nothing. You're just making sure that when you pass, those assets get distributed to your beneficiaries right away. We even have a 7-day money back guarantee. Try it out. If you don't like it for any reason, as long as you haven't downloaded any of your documents, we'll give you your money back, no questions asked. All of this for both spouses. Not only do you get to create all of these documents, but anytime there's a life event that happens, you can log back into your plan and you can edit your documents at any time. And here's the best part. We don't have any subscription fees. Most companies charge $10 to $30 a month to keep your account open and active. We don't charge anything. Once you pay the one-time fee to get started, you have free, full lifetime access to your account so that you always have the ability to protect your legacy. So why is estate planning so important? We talked about it, right? We talked about the need for a company like NetLaw to exist so you have an easier way to create your estate planning documents. We have the ability to create all of these documents and edit your documents at any time. So you stay in full control of everything. But the last 4 slides I'm going to show you, we're going to talk about the ramification part. What happens if we don't have these documents? When you pass away without a will, that will start a process called intestate. Intestate, and I promise this is the only legal term I'll use. Intestate simply means that you passed away and you didn't have a will created. So the state will come in and dictate how your assets are distributed. Nobody wants that, right? We don't want any kind of government interference. Having this will allows us to list all of our assets and name those beneficiaries to make sure that everything that you have gets to the correct individuals. No government interference. Speaking of that, if both spouses pass away and they have children under the age of 18, without a will, a judge will dictate who gets custody of your kids. Now, there's, 54 of us on here. I know all 54 of us don't agree on everything. But I bet we all agree that having a judge make that decision might be a bad idea. We know who's best to raise our kids. We know who we want to raise our kids. I am not going to leave it up to a judge to hopefully make the right decision. Having that will allows us to list those guardians of the people that we want to raise our children. And not only that, whoever the judge picks has control of all the inheritance that you left behind for your kids until they turn 18. Another major reason of why we need to pick that person. And we want to keep our executors out of probate court. Making sure that our assets get distributed to our beneficiaries is so important. But if we do not have the trust and you have to fight the probate process, it's time consuming, it's expensive. You have to hire an attorney, you have to go to court, you have to fight all the creditors. But simply creating that trust, transferring those assets into the trust, stops all of that. We even have a funding instruction sheet that walks you through how to transfer these assets into your trust. It's very simple to do. Last slide. Don't skip out on the medical documents. These are just as important as your financial documents. Making sure that you stay in control of everything. The one thing we don't want to happen is you're at end of life, you're in the hospital, your family's huddled up in a corner somewhere fighting over the care that they think that you may or may not have wanted. But having all of this listed out ensures that all of your wishes are followed through with. I can't stress enough how important that is. This is what we do every day at NetLaw. We've helped out thousands and thousands and thousands of clients with a very easy to use software. Now, I always compare this software to like TurboTax or H&R Block. 10, 15 years ago, no one was doing their taxes online. Now, who doesn't do their taxes online? It's easy. The software is very easy to use. It's inexpensive. We all didn't become CPAs overnight, but a software was developed for us to be able to create our taxes. That software exists for your estate planning, and it's NetLaw. So I'll stop here, and let me turn it back over to you. If anyone has any questions, I'm more than happy to go ahead and answer those now.
Yeah, thank you, Mark. Before that, if you have any questions, please raise your electronic hand and we can ask the question. And before that, I want to share one thing, Mark, if you are okay. So these questions you need to answer yourself. Is estate planning right for you? There's a take a short quiz. Meanwhile, you can go ahead, ask the questions. Surya, please go ahead.
Hi, Mark. Thanks for fantastic session on the will and trust. Actually, the thing is, right, I have one question in the specific bequest area, right? For example, let's say that if I have crowdfunding kind of thing, it's not like my direct investment. There are hundreds of shareholders are there in that investment. Then how we can list that?
Yeah, so go ahead and list that you have, like a crypto account or something like that, right? Go ahead and list that, and your shares would be distributed to your beneficiaries. So just, don't put the percentage of the shares that you own. Go ahead and
Where
put
you
the
want to,
full
in the
category.
specific bequest area, we have to do it. For
You're
example,
correct. In the specific bequest section, that's where you would list
even
it.
that crowdfunding is, let's say that it is real estate. Still, I have to enter there only, not
Yeah,
real
you'd
estate
still want
area.
to list everything because if your family's unaware of it, you still want it listed somewhere so they can go find out what part you owned on that.
But then, how I can get like, right? See, I can list. Then how I can move that asset to the trust?
Well, I don't know if there's anything really to transfer into the trust. Is there on your cloud funding, is there a account that's been created where you're listed as one of the owners?
Yeah, there will be some document there. They
Yeah,
will mention
then
all.
I would go back, take your name out as the owner and put your revocable living trust in as the owner. And then that will be owned by the trust, which will transfer to your beneficiaries right away.
Okay. You are saying that we need to request them to, in place of my name, we need to ask them to request, replace with our trust name so that
Absolutely.
it's moved to the trust. That's what,
Correct.
right?
You're correct.
Yeah, I have one question and more question. For example, let's say that my kids have the maybe like 529 plan or maybe IULs and all those things. Then since I'm not the, maybe myself or my wife, both are not owner for that, right? Maybe owner, then how we can mention that?
Yeah, I would definitely, that's going to be listed in your specific bequest section. You can just list because it's, if your kids are still minors, you still need to list that they have that that asset so that they still receive it. They'll receive it because it's going to be created in their name, but still, you want to make sure that the guardians are aware of that if both of you pass away.
Okay, thank you. Yeah.
Yeah, thank you, Surya. Next to Ankush, please go ahead.
Yeah,
Ankush.
thanks, Mark. First of all, I have specifically two questions. My first question is, what about our 401k and all those? Do we also have to mention that in the trust or in the will? How does that work?
Yeah, I would definitely list all of your assets in your will.
Even
Any of your
401k?
any of your assets that have named beneficiaries, like your 401k, you don't really have to put it inside the trust because anything that has a named beneficiary avoids probate automatically and will be transferred to your beneficiaries right away.
Okay. And like Surya asked about those, whatever we have, some bonds and all those. So do we have to, like, if suppose we have three different companies bond, do we have to mention company wise, or we just mention a rough that okay, these bonds, whatever it is, under this particular thing goes here, or
No,
it has to be very.
I would list all of them. I would list all of them. That way there's no confusion.
Okay, thank you.
Thank you. Next, Jitendra Soma. Next, Arunima
Yeah, hi.
Mantri. Yeah, go ahead, Jitendra.
Yeah, hi. This is Jitendra. I have a couple of questions. So, if my name, if my home is in my name, if I were to transfer it to the trust or will, would there be any transactions that would change, like the mortgage, or how easy or how hard is it to change it to a trust if it's already in my name?
Yeah, great question. No, No, because what we're transferring over is the deed of the property. The mortgage or any loans will stay in your individual name. So the only thing that we're going to transfer is the deed into the trust name.
Any tax implications if I transfer the deed to the
There's
trust?
not. It's still, yeah, because this is a revocable trust, it's going to treat you as an individual. So everything will
Okay.
come off of your social security number. So it's going to treat you as an individual.
Okay, and the second question is, would you like just in short let us know the process of doing this? Is it like just creating a login and doing it
It
in the
is.
netlog, or
Yeah, yeah. And I've even got a demo video, and I've shared this with Villas, and he can share it with you. But there's a demo video that walks you through how to complete all of the documents. And, we've got a great customer service. So once you start the process, if you get stuck, reach out to whoever invited you here. And if there's anything particular you need, in every NetLog client account, there's a chat bar. If you hit that chat bar, you can talk to one of our representatives. They can turn that chat into a video call where we can see your screen and we can help you.
okay? And so we don't need any advocate like lawyer or anybody else.
No, because the lawyers have already created the software.
Okay. Okay, thank you.
Thank you, Jitendra. Next, Dr. Arunima Mamidi. After that, I can go with Kamalakar.
Hi, thank you, Mark, and thank you, Vilas. I'm not well versed with these things. This is my first meeting. I have a two-part question. One is, a lot of us Indian women, we have jewelry, and how does that get valued, and how, because we would have bought it at some other point and the value was different then and as to now, especially
Absolutely.
gold.
Yeah.
That's one question. And the other one is, if we are doing the home onto a trust, right? We are not transferring directly to our kids. Like if we own a home,
Yeah.
what happens to the mortgage on it or whatever which is not paid off?
Yeah. The mortgage will stay in your individual name. You're just transferring the deed or the document that shows ownership. Your trust will own that house now. Your mortgage will stay in your individual name. So you don't have to worry about changing the mortgage. They wouldn't change it to the trust name anyway. So you're going to keep
What
your
happens
mortgage
after
in
we
your.
pass?
Say that again?
What happens after we pass away?
The property is going to transfer to your beneficiaries. When you're creating these documents, you're going to list your house and the beneficiary. So when you pass away, the property will go to the beneficiaries. If there's still a mortgage on your house, then they would use the estate money to pay off that, or they sell the house and just keep the proceeds of it.
Okay.
Yeah, and as far as the first question about the jewelry, yeah, you really would just put your jewelry down because you have no idea when you pass away what that jewelry is going to be worth. So you wouldn't put a monetary value. You would just put that you have this jewelry and name the beneficiaries.
Okay, thank you.
Thank you, Arumaji. Next, Kamalakar.
Yeah, thank you. Just a quick question, Mark. You mentioned that we can do edit whenever we can, and even the edits can happen like on the beneficiaries and whatever the people we can do every time, like it's a lifetime.
Yeah, so yeah, pretty much anything that you wanted to do, you can do. So you can add stuff, take stuff away. I think that was your question.
Right.
Yep, you have unlimited access to your account.
Okay, thank you, Kamalakar. I hope your question answered. Ajay Chaudhary, Kandula, please. You can unmute yourself, Ajay.
Hey, hi, Vilas. Hi, Mark, right? Okay. Thanks a lot for your time on this, Mark and Vilas. Thanks, Konda Reddy, for inviting me here. I had a few questions while going through this because I don't know if my question is answered, but if I have an IUL and the proceeds of which post, the proceeds of the IUL, I can just indicate it apart from the house and whatever assets you have. So my simple question is, if I put all of these into my will, would that be given out to my kids at that age when they are mature?
Mhm. But yeah, so you would use the children's trust to say, I have this IUL, but if something happens to me, you can't get the IUL till you're 25. Then they wouldn't get it till they're 25. So it would be, that IUL would just be held in trust until they turn 25, and then the executors will hand them over the IUL at that age.
Oh, okay. So it is not until they turn 25. Is that?
Well, I was just making that number up. It could be any number any age that you want.
Okay. Okay. No, actually at the time of, I don't know what's the usual time, but okay. Yeah. I'll check that out with Kondardu. Thank you, sir. Thank you very much.
Of course. Thank you. Thank you. Yeah.
Next to Alamu. I'm sorry, the name is Alamu. Raise the hand, please.
Sure. Thank you, Mark, for this wonderful webinar. So I do have a few questions. First, what is the difference between a will and a trust, and who should, what suits who better?
Yeah. So will and trust, two separate documents that do two totally different things.
Okay.
Your will is your listing document. I'm listing my executors. I'm listing my guardians. I'm listing all of my assets and who's going to get them. That's what you do in your will. Your trust is only designed to allow you to transfer those assets into the ownership of the trust. That way your beneficiaries get those assets right away. Without a trust, they're held in probate. Then the probate process goes through. Then they pass to your beneficiary. So the only reason that you have the trust is to make sure that your assets get to your beneficiaries right away. That's the two differences.
Okay, so either ways, we got to do both.
I would highly suggest you do both.
Okay. And what if you are, I heard you saying that your executor can be out of country, but someone in the state to kind of get through things here. So what if you are visiting, like, for example, if you're in India and you just happen to pass away there, what would that look like?
Yeah, you're nothing. Your executors will still handle everything. It doesn't matter where you passed away at. It's just making sure that those assets are in the US and we're taking care of them.
All right. And sorry, I have a list of questions here.
No, that's what we're here for. That's what we're here for.
The other is, what if you have some assets outside of the country, like inherited properties or something outside the country?
Yeah, you would still do your will and trust over in that country as well, because you have to follow the law of the land over there. But you can absolutely list your international properties or your international assets into your will, so your executor knows everything that you have, so that everything gets distributed at one time and nothing gets mistakenly forgotten.
Okay. And you can still, so basically in that case, you list it here to just make them aware of it, but you also do it in the other country.
Yeah, you do, because these documents are only valid in the US, so you can't take these documents back over to India or anything like that. Yeah.
Makes sense. One last question is, I remember someone asking about the bonds, and you said it's a good idea to list them individually. But what if you have like stocks or shares, and it's when you make the will, it's something, but then in the future your portfolio changes.
Yeah.
So do you keep changing that maybe now and then, or can you
You could
just
just
say
put
this
your
entire
stock
account?
if you didn't want to list that, you could just put your stock portfolio down.
Okay.
Usually it's all in one account. So, you could what I would do is list your financial advisor that you're using for your stocks, or if it's stocks through a company that you work for, just go ahead and list it that way.
Okay. Instead of individual. Makes sense. Thank you so much. Thank you.
Yeah.
Thank you, Alamu. Thank you so much for your questions. And next to Keshav Ande. After that, Ramana will ask the question. So there are two Ramanas. We'll go for Ramana N and after Ramana Palle. Go ahead, Keshav.
Sure, yeah. Hi, Mark. Thanks for the session. And my question is on the topic of the primary home that you mentioned, that we can fund it into the trust. I have other question on the rental home. Like if I have a rental home and I do remember, I mean, for me at least, knowingly or unknowingly, I did something called land trust. Okay. And that's what helped me. But I'm wondering,
Yeah.
like, is the Netla offering the land trusts also, or it's only?
We don't through this software, but yeah, we do land trust through our attorneys. So if you needed to review that or get a new land trust, definitely get with whoever invited you here. They'll get with me, and I can connect you with one of our attorneys to help you with that.
Okay. But you can help with your attorney by connecting offline.
Absolutely.
Okay.
Absolutely.
Got it. Got it.
Yeah.
Yeah. I do have some needs, so maybe I'll connect with you.
Yeah. Perfect. Perfect.
Yeah. Appreciate that.
Yeah.
Thank you.
Thanks.
Yeah. And the second question, sorry, on the primary home, when we do, like sometimes, like, people list the kids as their beneficiary, as in the deed itself sometimes. I just want to get your perspective on that. Like, looks like that may not be a good idea, I'm thinking, but I want to hear from you. When we have a revocable living trust already replaced, so that is
Yeah.
having already beneficiary, so there is no point of keeping the kid's name on the property, right? Like directly on the deed.
Yeah. So, it's, there's good and bad things to everything, right? So, if you have your children on the deed of the house, it's their property as well. So if anything happens between the families and they get into arguments, that could cause an issue. So if you want to just keep it in the ownership of you and your spouse and just make them the beneficiaries, and if anything changes, you can just change the beneficiaries. But if anything happens and they're the owners of that house, or part owners, that could cause problems.
Okay. Yeah, as long as we put the revocable living trust, it may not make sense, I think.
Yeah.
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 Because one of the home I need to get rid of that.
Yeah.
Yeah. Thank you.
Yeah. Thank you.
Yeah.
Thank you, Keshav. Next, Ramana N, please.
Hey, thanks for this call. I don't this call. Most of my questions have been answered, but I had one question about the rent bank locker. Like, in case something happens to both the parents, where and how should it be listed?
Yeah, so you could just put that you have a safety deposit box at the bank. Go ahead and put that in your specific bequest, and your beneficiaries will be able to access that. You could also put that as a named beneficiary at the bank as well. But still, it's a good idea to go ahead and list that in your will, just to make sure that your kids might not know that you have that. So let's list everything.
In case if they're minors, that's still the case.
If the children are minors, they wouldn't be able to access it or any of the money until they're 18. So the guardians would have control over that.
Okay. And my second question is, there are two different types of wills. Which one is used for which purpose?
Well, there's the last will and testament. That's the only one that we offer. That's in every one of our law offices.
Okay, thank you.
Thank you, Ramana. Next, Ramana Palle Garu.
Yeah, thanks, Vilas, and thanks, Mark. I have 4 questions. The first one is, what are estate taxes? Does this apply on the trust or will? And how different is it from the inheritance taxes? Does inheritance taxes apply on the trust? Those are the 2 questions. After that, I have 2 more questions.
Okay, yeah, let's answer those first because that's a lot right there.
Yes.
So inheritance tax, if you're a U.S. citizen or green card holder, inheritance tax doesn't play a part until like 28 million for a married couple. If you are not receiving assets over 28 million, there are no inheritance taxes.
Excellent.
If you're not a U.S. citizen or green card holder, it's 60,000. So big difference, right?
Yes. Yes.
So that's when inheritance taxes would come into play, along with your estate tax. Estate tax, inheritance tax, same thing.
So estate taxes are like an individual paying taxes, but estate is paying the taxes.
Yeah, your estate will pay all taxes due. Yeah, so your beneficiaries aren't responsible for your taxes. Your estate is.
Okay, so I'm going to the third question. Let's say there are no debts. what are my options to liquidate all my assets after the will turns irrevocable?
Well, yeah. So once you pass away, all of your assets are really frozen. No one can do anything with them except the executor, and that's just transferring them to the beneficiaries, right? So once you pass, there's nothing anybody can do except distribute those assets to your beneficiaries, and then they can take the money out of the bank account. They can cash in the 401k and the life insurance. But as far as that, once you pass away, all of your assets become irrevocable.
So I can liquidate them and I can transfer to individual accounts, meaning
Mhm.
whoever is executor is.
Yeah, yeah. Before you pass, yes.
After some the trustee is passed and whoever is handling the next trustee, does that person can sell everything and distribute it to the
They can't sell it unless they're the beneficiary. They can't sell it. Their only job is to distribute to the beneficiaries.
okay. And is it true that the capital gains that have accumulated until the person died are not taxed,
Correct.
and the capital gain starts
Yeah.
as the assets accumulate after the death?
Right. It's like if you've ever heard of like step up and basis tax,
Yes.
kind of
Yes.
the same thing. That means, let's say, and I'm going to use very generic numbers. You bought a house for 100,000 and you sold it for 500,000. The step up would be the 400,000.
Yes.
But your estate is not responsible for that. That goes to your beneficiaries, and when they sell that house, they're responsible for that. Now, again, a lot of those taxes are included in your estate tax, so that would be included in the 28 million.
Okay. Thank you, Mark.
Mm-hmm.
Thank you, Ramana. Next, Sri, iPhone, please.
Hi. Thank you. Appreciate the opportunity. Couple of questions. So, if I understand this correctly, NetLaw is a software we need to download and apply. So fill your own documentation, right?
Yeah,
Means
it's a software. It's cloud based. So it is a software that you're going to use to create your documents, print them out, get them witnessed and notarized.
right during the filling the documentation, I can get the customer service help. The
Mhm.
step 0 to step 10 will take care of it. Right?
Absolutely.
Okay.
Absolutely.
Sounds good. So let's pretend you finished all the steps. You click the print button. So what next? I
Yeah,
have
you
a
print out your documents. Yeah, you print out your documents, you get them witnessed and notarized. Then you transfer your assets into the trust. And then the last step would be taking those documents that you had signed and witnessed. So you have your hard copies. Go ahead and scan them back into your NetLaw software. You can actually create a folder. So you have a digital copy of your documents and a hard copy.
And you notarize. And do I need to do anything? Several people ask the questions on the home and everything. Do I need to do anything down, give it to the township or municipality to get notify that this home are part of the trust?
Yeah, you wouldn't have to do anything. Once you complete the documents, you transfer the assets into the trust, you're really done for right now. Now, when you pass away, your executors are going to have to file your will with the county records department. But that's about it.
So, and is the executors or successor whoever, they need to have a copy of that?
That's a very good idea. Yes, your executors, your adult children, your guardians, I would give them all a copy of it. So in case something happens and you pass away unexpectedly, they're ready to go. Because
So, and I don't.
well, right,
Go
because the one thing we don't want you to do is you do all of this, something happens and no one can find your documents, right? So we want to make sure that people have this.
And since homes, banks, and everything, since everything is transferred to the trustees, the trust, do I need to inform the mortgage people that this has been?
No, no, we're only transferring the deed into the trust. Your mortgage, all of your loans will stay in your individual name.
Okay, all right. So basically, in short, I don't have to inform anybody except take a printout, notarize it, give it to the whoever is the responsible people. That's it.
Yeah, and get the assets transferred into the trust name.
That's okay. Got it. Thank you.
Mm-hmm.
Thank you, Sri. And next to Balu, after that, Surya. I have some of the questions in the chat window. I will call soon those also. Balu, please go ahead. Please unmute yourself.
Yeah, and I have a hard stop in about 6 minutes because I have a 4
Okay,
o'clock.
sure, definitely.
Yeah,
After that,
can
we
you
can
hear me now?
continue. We have some suggestions and some last minute discussion.
Yeah.
Stay again once Mark will. Balu, please go ahead.
Yeah, my question is, if I file a homestead exemption with the state, do I have to go and notify the state that the property is not in my name, is transferred to the trust?
Absolutely not. Inside our trust documents are the wording for your homestead exemption, so you don't have to do anything.
Okay, thank you.
Thank you, Bala.
That's it.
And Ajay, you want to ask the questions?
Oh, sure. I want to ask, but I want to simply ask only one question. I have a lot of them, but
Please go ahead, Ajay. It is helpful for other people.
yeah, the last question I want to ask is, so what are the mistakes? Okay, so the mistakes can happen anywhere. Okay, so when we are setting up, revocable living trusts, okay, and then we fail to properly fund or maintain them. Okay, I mean, what are the biggest mistakes that you would see when people set up revocable living trusts? That's what my question is.
Yeah, that's a really good question. So, you'll be surprised, but here are the biggest things that people don't do. They'll create the software, they'll create all the documents, and they don't take it to get it witnessed and notarized. They just stop. Don't do that. Don't do that. Now, as far as mistakes that they found, they inputted an asset that 2 years later they've sold and they haven't came back and edited the documents. Remember, you have free edits to this. Take out what you don't have anymore, add in everything new. The biggest things that people do is they don't take assets out that they don't have anymore, and they don't include the assets that they purchased later after they created the will and trust. Make sure that we keep all of this up to date. That's the biggest mistake people make, because the assets that you acquire later, if they're not in the trust, they go to probate.
Okay.
Even though you have the trust.
But do they need to notarize every time?
Absolutely. Anytime you edit it, you have to witness and notarize it.
Okay. So that brings me. I mean, if I can have a few more seconds of your time, sir. Okay.
Yeah.
Like in practice, what are the top 3 reasons wills and trusts get challenged in court, and how do you draft differently to reduce those risks?
Yeah.
I mean, you would be more knowledgeable on that. So.
Yeah. Well, the good and bad thing about the U.S. court system is you can challenge anybody for any reason.
Okay.
But I will tell you, in the 13 years we've been in existence, we've never had a document fail in court. We've had people challenge them, but we've never lost.
I mean, that's good to know.
Well, and there's a reason for that. These documents have been created by attorneys. This isn't a generic software. These are the same documents you're getting in our court system. So, and the reason, he promised me this or she promised me this, but when you have these documents, everything is set according to the state law. If you've done these documents, you've got them witnessed and notarized, it's very hard to lose in court.
Okay. Okay, sounds good.
Thank you, Ajay. And Raj C, please go ahead the question. Please unmute yourself. And Ramana, Surya, you have any questions? Still your
Yes.
hand is raised.
Yeah. Yes. Yeah. If somebody is there, I will give chance to them.
Raj,
Later I will ask.
Rasi. Okay, Rasi, I have 2 kids, one turning 18 in couple of months. If I execute will now with friends, family as executor and guardian, can I change it to my major kid once turn 18? If yes, can I do it online?
Absolutely. Yeah, everything's done online. You would just log back in, take the person out, add your child in.
Okay. Thank you. Yeah, Surya. Before that, Surya, please go ahead.
Yeah. Yeah, Mark, I have one question. Let's assume that like we have two kids and one kid is adult, and I have mentioned one kid as a right such a trustee and as well as beneficiary. Is it okay?
Yeah, absolutely. As long, yeah. Yeah, anytime that you're, as long as you're over the age of 18, you can be successor trustee, you can be guardians, along with beneficiaries. So, you have control over everything once you're 18. They can be everything.
Okay. Another
Now,
question
I
is,
wouldn't name an 18-year-old maybe as the guardian, right? Yeah, they're 18. Hard enough to take care of themselves, let alone an 11-year-old.
Mhm. But what about this thing? For example, I have bank account, okay? As you told that I have not mentioned that in the will or trust, okay? Will and trust.
Yeah.
Then assume that, okay, kids are minor, but I have mentioned my kids as a beneficiaries. But you told me that like you told us like beneficiary whoever is right as our successor trustee or guardian will take care. How they
Yes.
will have access? Why we have not mentioned right anywhere in the trust document we have mentioned in will and trust. So and so person is a guardian and so person is a successor trustee and all those things. But
Yeah.
in my bank account I have not mentioned. Then how they can access that?
Through the court system. Once they see that you and your wife have passed away,
Mhm.
your account will remain open because there's money in there. Now, what the guardians are usually going to do is they're going to come in and they're going to show that you and your spouse have both passed away and that you named the kids as beneficiary. They're going to say, beneficiary. Remember, the role of the executor is to take that and transfer it to the beneficiaries. The guardians will then open up an account for the kids and the money will go into their accounts. But they're under the age of 18, so they can't get into it. The guardians have control over that.
Okay. Okay, thank you.
Yeah. All right. Oh, I do have to jump off. I've got to be at another meeting.
Okay, thank you, Mark. Okay, yeah, other people, you can stay one more minute. Let's have. Thank you, Mark, for the session.
Thank you so much. Thank you, everybody.
Yeah.
Yeah,
Thank you,
thanks very
everyone,
much,
for
Mark.
joining.
Thank you so
Wonderful
much,
session.
Mark. Thank you.
Who invited, please contact them. They will give 10% discount. Generally, the cost is $600. Just let me share the screen if you are okay. 1 minute. So this is a package it will include. So, okay, already Mark explained, just I want to make sure. So last will, revocable living trust as a children trust, durable financial power of attorney, and IPA authorization. Okay, these all the documents, a pre-spouse plan, it is okay. So you need to answer these all the 10 questions. If you have any need these questions, you can check these 10 questions. Take the photo for that, screenshot for this one. So mention all. If any 10 items, if anything, one is no, you need to contact who invited to today's session. If any kids are special kids, they have special needs trust, that is the cost is separately $750. But a regular will and trust is the $600. But who invited, you may contact them. So these are the roles and responsibilities. Okay. And yeah, these are the things. And if you have any questions, please reach out to your contact person. And this is the cost for probate, generally $600. But you can reach out to your, please sign up today only. If you sign up today, it is a 10% discount. Regular cost is $600. You need to do one thing. Who invited, you need to send the last, please provide below details, first name, last name, email ID, mobile number. So who invited them, say to thank you and refer to your friends. And this is one of the important, you can charge it, I mean, you ask in the, you use regular ChatGPT or Google. Is a will and trust is it mandatory in USA or not? So what if not? So just check with them, and who invited to them, just inform to them and contact, reach out to today. Don't delay this process. Okay. Thank you, everyone. And special thanks to each and everyone, because today you joined means you are caring for your family. And a special thanks to each and everyone. Have a great day. Bye-bye. Thank you.
Thank you, Vilas.
Thank you, Vilas.
Thank you.
Thanks, Lord Vilas.
Sure.